but also to question whether or why we can say people should be detained on the basis of their citizenship or on the basis of their membership of an ethnic, religious, or political group or minority, to be more precise, as it happens in the two areas we are exploring today, when there is a state of a public emergency or in relation to immigration detention. These are two contexts in which incarceration has overstepped the usual boundaries of criminal proceedings. The use of administrative detention is well known within the context of crisis, where states face terrorism threats or alleged terrorism threats, and where governments normally confer upon themselves the power to detain, to order detention without trial. The significant increase in the use of arbitrary detention reveals how personal liberty is normally the first sacrificial victim on the altar of a public emergency. If you look at recent derogation from the European Convention of Human Rights, derogation for counter-terrorism purposes, I mean, you will see how the common element to the emergencies in Ukraine, Turkey, and France includes the adoption of measures that significantly reduce the applicability of the right to liberty under Article 5 of the European Convention of Human Rights. In France, the emergency law granted the Minister of Interior the power to order the house arrest of a person, initially for an indefinite length and without any judicial control. In Ukraine and Turkey, the exceptional legislation introduced extended preventive detention, so detention without any judicial review, to 30 days. But if we look back at the practice of those countries that have mostly used the derogation clause under Article 15 of the European Convention of Human Rights, you will see how the UK, in relation to the situation in Northern Ireland, and Turkey, in relation to the Kurdish cause, have made frequent use of administrative detention to confront public emergencies. But moving to the second area we are going to explore today, the increasing recourse to administrative detention is also linked to the extension of the notion of security to another aspect of state sovereignty, the state's exclusive determination of the entry, residence, and expulsions of individuals within its territory. In particular, administrative detention is widely used against irregular migrants and asylum seekers, such as those subject to border procedures or to so-called Dublin transfers. These coercive measures raise human rights concerns in relation to the condition of detention, of course exacerbated by the spread of COVID-19, but also in relation to the governance and the experience of confinement, as well as in relation to the access and enforcement of fundamental rights. Effects of detention include physical and psychological distress, the separation of families, difficulties for detainees to obtain or retain legal advice, and the lack of clarity about the period of confinement, just to name a few of such problematic issues. So, in this context, characterized by a decriminalization of state sanction and the increasing predominance of security as the guiding orientation for the exercise of state punishment that I tried, of course, for a matter of time briefly to outline, today's speakers, who are among the major experts in the field of detention and human rights, I don't think they need any presentation, they will address the tensions between administrative detention in the two areas I mentioned and international human rights standards, in particular tensions with the European system of protection of human rights. And they will also explore human rights implication of immigration detention in a number of countries, including the US, Italy, and the UK. So the first panel includes three presentations. We have the honor today, really, to host Professor Fenula Niolen, my apologies for my Irish accent, Professor Judge Paolo Pinto del Albuquerque, and Professor Elena Valentini. Just a small change, so Judge Turkovic just informed us that she's in a meeting and she will join us for the second panel. So that's why we made this little change. So the first speaker is Professor Fenula Njolen, Special Rapporteur on Counterterrorism and Human Rights. She's professor both at the University of Minnesota and Queen's University of Belfast. She's the recipient of several academic awards and honors. She has widely published in the fields of emergency powers, conflict regulation, transitional justice, and sex-based violence in times of war. I don't think there is any scholar working in the field of counterterrorism and human rights who have not read her brilliant books, and in particular, or well, more in general, her publications. Or just to mention her amazing book titled The Law in Time of Crisis, published by CUP, if I'm not wrong, in 2006. Without any further ado, we look forward to listening to the first presentation today. Professor Njolen, the floor is yours.
Thank you, and I'm really delighted to be here and to be part of such an esteemed conversation. I'm particularly pleased to join all colleagues and friends, including those from the court. So it's a real pleasure to be here. So let me do a couple of things. My remarks are really structured around a series of observations. They are observations that include observations on derogation. They include observations in particular on the practices we're seeing of detention, particularly in the area of security and counterterrorism. And I'm going to close with some observations related to the contemporary moment, the relationship of the pandemic to some of these broader conversations. So let me start by setting out some things that everybody knows, but just to create the playing field of where we're in. So as we all know, international law recognizes the permissibility of certain restrictions on certain rights and freedoms during emergencies, and enables governments to take measures that are necessary, proportionate, and consistent with the state's international law obligations. But as we all also know, emergencies are fraught contexts where the possibility of state overreach and state abuse of individual rights is always present, as is the omnipotent potential for group stigmatization and exclusion by virtue of the application of exceptional law, usually allied with exceptional political rhetoric. This kind of overreach can manifest in both obvious and non-obvious ways. Traditional state emergency mobilization has included the police, the military, and the courts, regulating the actions of both state and non-state actors, primarily through legal process and the use of force. But in the last decade, it seems to me that we can see a range of new trends that can be discerned in emergency practice, which include the mobilization in particular of the administrative state to direct its multifaceted powers towards whatever the stated emergency may be. This mobilization of administrative state has, I think, involved, and we've seen, the use of a range of governmental ministries and the versatile deployment of military and other security actors beyond the use of force to regulate in spaces that have been traditionally reserved to other entities. And I think the multiple national level emergencies that have been occasioned by the COVID-19 pandemic, I see as exacerbating and intensifying this trend, something I'm going to return to at the end of my remarks. So just a couple of formalistic points about derogation or emergencies. As we know that the major sort of feature of many regional international human rights treaties is that they explicitly acknowledge and provide for the experience of crisis or emergency by states. And that accommodation mechanism is enabled by the process of derogation. And that is a privilege given to states to restrict certain individual rights in certain exceptional circumstances, whether those be war or emergency. And as we know, in the European context, a variety of words are used to describe what that might be: war or other public emergency threatening the life of the nation, and similar terminology is found in other covenants or treaties. Now, it's also important to note that the scale of the threat to the state is, in theory, is supposed to be exceptional, and it has to affect the fundamental capacity of the state to function effectively. And I think what's important, and we all know this, I think, that for a state to engage in emergency practice, it need not enact specific emergency legislation for derogation to follow, so that ordinary law or practice which is sufficiently encroaching on individual rights can in fact bring us to a de facto exercise of emergency powers. And I think that's particularly important because historically our focus has been on things called emergency powers, emergency in the title, so we all know what we're looking at. But in reality, I think, as the mandate I hold, as a number of other international observers and scholars have pointed out, that sort of formalistic statement of emergency is less evident than it used to be. And the normalization of emergency in regular law is probably the most pernicious challenge we face in terms of the practice of emergency powers in the current moment. And again, just to say, the link that's really important here to the COVID-19 moment is that we're finding emergency powers effectively tucked away in things called sanitation bills or health bills or other pieces of legislation that sit in an entirely different area of state regulation, primarily health law. And I think that's going to stretch some of these challenges even further. Now, one of the things that I want to note in particular is that despite the proliferation of emergencies of various kinds, but particularly I want to focus on the kinds of challenges that have been faced in the context of terrorism and armed conflict, and we've seen an acceleration of the use of these powers since 9/11. It's important for us to know that the resort to formal declarations of emergency is on the wane. States are failing to derogate, even in contexts where their actions reflect de facto suspension of both derogable and sometimes non-derogable rights. So this non-derogation practice is occurring notwithstanding the exceptional use of national security or both traditional and de facto emergency powers. And this, in my view, has the effect in practice of creating emergency practices and conditions that are largely under-regulated or under-noticed. And my report to the Human Rights Council in 2018 really reflected on this link between emergency powers related to counterterrorism law and practice and the failure to derogate, the failure to name these things precisely as a form of emergency practice. It seems to me that treaty bodies have been ill-informed and under-notified of the consequences of both state security and counterterrorism measures for rights protection. The failure to derogate is a serious and emerging practice that, in my view, has to be significantly addressed in order to ensure that we actually have legal oversight of emergency powers from the supranational to the national. Again, this trend appears also to be consolidating and expanding in the context of derogation in the context of COVID-19. Data that at least is available to me, but others may have more up-to-date data, suggests that only 30 countries have entered formal derogations in respect of measures taken in response to the health crisis, notwithstanding the extensive restrictions that we've seen on freedom of movement, assembly, and association connected with the pandemic. So that's a really significant gap, I think. And I mean, I would suggest, just again, thinking about the pandemic would appear to be a classic emergency, a proper use of the derogation opportunity. And it seems to me also that states should reasonably feel that human rights courts and oversight bodies, if there's litigation, would give a significant degree of deference in their assessment to the crisis, the scale and scope of the measures needed to confront it. Nevertheless, derogation appears to be on the wane even in these exceptional circumstances, confirming the trend towards the normalization of the exception and the avoidance of the constraints of exceptionality and oversight that would follow from naming the fact that the state is in an exceptional moment, whatever that may be. So let me make some observations about the deprivation of liberty, and at least from my perch, what I'm seeing here. As Special Rapporteur, I have the opportunity, for better or worse, to observe global patterns, and particular to observe the kinds of deprivations of liberty that we're seeing in the counterterrorism, extremism, violent extremism, radicalization contexts. And one of the things I do want to note is just a word about nomenclature. Because increasingly there's a vocabulary of words, some of which I've named, counterterrorism, extremism, and radicalization, being used interchangeably, and also legislation at national level operating interchangeably to restrict rights in this space. We also see in some countries words like sedition or insurrection or separation being used. So the one sort of thing I would say to international lawyers is if we only look for the word counterterrorism or security, we're going to miss a range of practices that are in fact sort of functioning on a wide spectrum and being used interchangeably by states in order to engage in rights restricting activity, often using certain nomenclature, sometimes to avoid the particular perception of oversight that may go with one versus the other. So what are we seeing? Well, I think the first thing I'm seeing is extraordinary legislative expansions in the field of counterterrorism. Some of that is mandated by Security Council resolutions. UN Security Council Resolution 1373, which is almost 20 years old, actually requires every state under a Chapter 7 resolution to have counterterrorism legislation. And there's an infamous debate or exchange between a government which shall not be named and the Counterterrorism Committee in 2002, where the government appeared before the committee and said, well, we don't have counterterrorism legislation because we don't need it. It was a small island, let me just give that away. And the committee responded, well, it's really irrelevant whether you need it or not. You're mandated to have it under Chapter 7. So again, there's a propulsion to regulate here for some countries, not all, that's unrelated to whether or not the powers and the means are necessary and required in the specific national context. And the mandate closely follows national legislative developments. And what I can tell you is we see a tsunami of legislation of opaque and imprecise nature, where the term terrorism, extremism, or violent extremism, bearing in mind that there's no agreed definition of any of those terms under international law, where the state essentially chooses to define those terms whichever way it wants. And we're increasingly seeing restrictions on legitimately protected rights under international law. Speech, assembly are two very specific examples, but not only. It's also important to note that during COVID, we've also seen an expansion of that legislation. And I particularly note in the European context legislation that's emerged from France and from the United Kingdom, which my mandate has made a number of observations on, and most particularly inquired about the necessity of passing this kind of legislation during a pandemic when there was not enough time and capacity to really focus and engage public debate on the content of that legislation. We also have a new EU plan of action on counterterrorism, which seeks, I think, to make significant inroads in the right space. So legislative expansion is one big trend with impact on deprivations of liberty. Secondly, in my view, counterterrorism regulation is having what I see as a pincer-like movement from two sides on the protection of liberty. It's being attacked in some way from two ends, one which has already been articulated by our chair. We're seeing precautionary criminal law, pre-criminal law expanding, and preparatory acts, particularly acts that go to speech. So apology for terrorism is a really good example, or other acts like travel, which arguably there's a portion of the right to movement which is protected by international law, including the right to return to your country. And those are being criminalized. So this pre-criminal space is expanding significantly. At the other end of that is the post-criminal space, or the point at which a person has concluded their criminal sentence for a particular act of terrorism or extremism. And there what we're seeing are the accumulation of other measures in that space, particularly administrative measures, which in my view, in many cases, amount to a de facto deprivation of liberty, particularly where those administrative measures are piled up. And I would refer to the mandate's report on, in particular, the use of administrative measures in France in this regard. So we see a sort of a seamless move from traditional offenses that are expanding, the exercise of the criminal law, and then a seamless move into administrative law, which has multiple measures then piling up, often in excessive, in my view, and disproportionate ways. That's the second trend. The third is the intersection more broadly of administrative measures with civil restrictions and the criminal law. Everything from territorial limitations on where a person can move to or out of, to restrictions on maintaining in the home, restrictions on association, restrictions on what mosques. These are generally, the restrictions have also raised serious concerns about religious liberty, but we see an intersection of these measures across multiple legal regimes, making the terrain extremely difficult to manage. Fourth, what we're seeing is prolonged arbitrary detention without derogation. And so there, I just want to point to probably the most egregious example of this, which is Guantanamo Bay, Cuba. On the 11th of January, just a couple of weeks ago, we celebrated, if that's the right word, the formal confirmation by the US government that this center was being used as a detention and criminal space. 19 years later, we have 40 persons still being held in a legal black hole who range in age from 38 to 73. 2 of the current detainees have been there for 19 years. 60% of the population were previously held in a black site. All 40 of the persons currently being held in Guantanamo Bay, Cuba, have been in US custody for over 13 years, 36 of them for over a decade and a half. Only 1 of them has had a trial to which there has been severe concerns about the fairness and appropriateness of the charges that were applied. So I also just want to note the legal liabilities that have not been fully settled about the role of a number of European states in the rendition process, which led to those 40 individuals still being held. But that example of 20-year arbitrary detention and the failure to resolve or account for it seems to me to really underscore the challenges that we are seeing and the simple lack of legal remedy, which seems extraordinary. Fifthly, I want to focus on the practices of transfer that we're seeing. So many of these are formally deemed to be legal transfer between states involving mutual guarantees, but those transfers often involve significant issues of deprivation of liberty, and despite formal procedural legality, are often really deficit from a human rights perspective. And as the mandate I hold has articulated, we're seeing increased instances of outright kidnapping involving the transfer of person between states with no legal process whatsoever. Sixthly, we are seeing in the space I work in the emergence of what are often called re-education camps or centers for de-radicalization or ending or extremism, proliferating in numerous countries. These camps, of course, raise profound concerns about that the confinement of person involves unlawful deprivation of liberty, particularly when release is dependent on those who are being held subscribing to what might be called accepted notions of religious theology. And these are not, this kind of practices, these are not just happening in places far away. The mandate has commented on places like the Kingdom of Saudi Arabia and Kazakhstan, but we see this move towards de-radicalization connected to release of persons also emerging in European space. Seventhly, we see the intersection of migration detention and counterterrorism, particularly in the context of citizenship stripping and non-refoulement. Finally, let me just say the 8th trend is the health detention space. And I think that raises some really interesting questions about the transfer of CT practices into health, but also at the end of the pandemic, the likelihood that some of these detention measures, including compulsory quarantining, may in fact reemerge in another form. We've seen litigation. There's interesting litigations in countries as diverse as El Salvador and Botswana emerging on these cases. Let me conclude with some final observations, having outlined those trends. And I really want to focus on COVID-19. I think the COVID-19 pandemic is producing a number of effects on emergency practice. I note that one of the distinguishing features of pandemic regulation, anecdotally, appears to be the ways in which, by both necessity and political convenience, there's a wide spectrum of emergency regulation appearing. So a narrow focus on national level regulation, i.e. central government regulation, is important, but it may be somewhat misleading, as subnational, particularly city and regional responses may constitute the more impactful and legally significant set of emergency practices, including around detention, and that we need to document in the short, medium, and long term. This also leads to the obvious observation that it is the intersection of multiple layers of emergency practice in any particular country, central government plus city plus regional plus municipality, that will precisely illustrate for us the combined effects of multiple emergency powers and practices. It's also important to underscore that the overlap between some of the agencies leading responses to counterterrorism and security and those who've been designated to enforce powers to prevent the spread of COVID-19 may have an ill-advised effect on entrenching and legitimizing the security state. It's patently clear that the use of existing, particularly terrorism and security-focused powers, is on the rise in the COVID-19 context. I am particularly concerned about the adaptation of security and counterterrorism measures, which have been in place prior to COVID-19, that are now finding themselves repurposed to a health emergency. And that's a very easy move for states. But as I've noted elsewhere, this is happening precisely because many states have an arsenal of emergency powers available to them already. And domestic counterterrorism legislation may be sufficiently broad and enabling that it can be repurposed with no intervening legal act required, which is what the mandate is seeing in a number of countries. So we're seeing a number of states functioning under an existing emerging state of emergency that don't need to ask for COVID-19 powers because they have enough already. It seems to me particularly concerning that this adaptive use of exceptionality in this context is particularly problematic when we know epidemiologically that the groups in societies most at risk in the pandemic are those who are marginalized, those who are ethnically and raced communities, and the extent to which the pre-existing negative relationships of those communities with the security sector will now be further compounded by the regulation of those communities through the augmented powers of the security sector in a COVID-19 context. So I think that's something for us all to pause, and there I will stop.
Sorry, can you hear me now?
Yeah.
My
yes,
microphone was off. Well, to listen to you better. So many thanks for your absolutely inspiring presentation. Really a lot of food for thought. But I mean, for a matter of time, I will just now give the floor to our second speaker, Professor Judge Paolo Pinto de Albuquerque, who has served as a judge in various courts in Lisbon and as an expert with the Council of Europe group of states against corruption. He was elected judge at the European Convention of Human Rights in 2011, and he was the vice president of Section 4 and the president of the Committee on the Rules of the Court. He was member of the Grand Chambre panel and the founder and president of the Criminal Law Group. He's also a full professor at the Faculty of Law of the Catholic University of Lisbon. In this capacity, he has published, I think, 23 books in different languages, and please tell me if there is something new just in the last few days, and 65 journal articles. And he has significantly contributed to the development of international human rights law by authoring 157 opinions in Strasbourg. Apologies for the self-promotion, but I will take the advantage of my position as a chair of this panel to let you know that we have just published this book that you can see here on the judge's work at the European Court of Human Rights, the first English written book on the legacy of Judge Professor Albuquerque at the European Court of Human Rights. Professor Judge Albuquerque, the floor is yours.
Thank you so much, dear friend, dear Tristino. First of all, I would like to thank you for the invitation. It's really a pleasure to be here to address this audience of 127 people. It's really amazing. On this very hot topic, it's indeed a very important topic, which has been dealt with by the court since long ago, and I mean the European Court of Human Rights, of course. I will try to present briefly the main reasons why I am so critical of the case law of the court. The case law of the court presents in many aspects a very asylum seeker friendly face, but on this issue of detention of migrants, the case law has been very much influenced by the UK situation, and I think you will notice from my presentation that the main cases that have structured the position of the court are those related to the UK, Sadi versus the United Kingdom and A and others versus the United Kingdom, 2008 and 2009 Grand Chamber judgments. So the issue of detention of migrants as a state policy must be analyzed from a broad perspective, which goes beyond the mere question of the material conditions of detention in individual cases. Over the past few years, there has been a trend towards crimmigration. And this concept I define as a process by which criminal law has been used to enforce immigration laws and punish immigration offenses, while immigration law has often been used as a tool of criminal policy. This trend can be found also in the way the court has dealt in the last 10 years with the migration of detention. What has happened is that state criminal law machinery, including detention, has been instrumentalized for the purpose of immigration enforcement. And similarly, expulsion and deportation measures and detention are imposed as a method of crime control. This policy, which perceives the migrant as the new enemy, has been tinged with the legacies of racism and xenophobia over the last 10 years, 20 years. It has the potential to create an atmosphere of hate and distrust towards immigrants across Europe. There are serious issues with the criminalization trend within the court. Let's start with the Sadi judgment. That judgment set a terrible precedent. The court held that the state may detain a temporarily admitted asylum seeker to prevent unauthorized entry and to expedite the asylum claim. In that case, the court also held that it is not relevant whether detention is necessary in order to prevent that irregular entry. Although the court in Sadi read into the first limb of Article 5.1f a requirement of non-arbitrariness, it also took away the necessity test from this analysis. While the detention of migrants should not be arbitrary and should be carried out in good faith, as the court suggests, it is obvious that the non-arbitrariness requirement does not provide the same degree of protection as the necessity test. What this shows, in the view of the Grand Chamber, is that migrants can be treated worse than ordinary criminals, whose detention must be necessary, simply because efficiency trumps liberty in migration law. A detention order for the sole purpose of state bureaucratic convenience equates the targeted people to commodities. This was an unfortunate departure from the necessity principle. In 2008, in this Sadi judgment, ultimately giving states a chèque en blanc to detain whenever they please without assessing possible less intrusive alternatives suited to each asylum seeker. Ultimately, the court's decision to adopt a bad faith criterion of the arbitrariness requirement worsens even further the legal situation of the asylum seeker, since it leaves, in practical terms, the asylum seeker's protection dependent on the court's assessment of the state of mind of the detaining authorities. In most cases, state authorities will likely be in a position to argue that they acted in good faith in detaining asylum seekers. The next year, in 2009, the Grand Chamber extended the Saadi's arbitrariness criterion to the second limb of Article 5(1)(f) in A and Others versus the United Kingdom, another case against the United Kingdom. Unfortunately, in this case, the court held any deprivation of liberty will only be justified for as long as deportation proceedings are in process and will cease to be justified if deportation is no longer feasible, even if the individual is refusing to cooperate. Within the court, of course, there has been a silent but growing revolt from some chambers against Saadi and its spillover effect in A and Others. In several cases, the court has held that detention of asylum seekers, including in alleged terrorist cases, are and should be dependent on a strictly necessity test. In general, this has been applied, I would say, and these are the most prominent cases: Luled Massoud versus Malta, Suzo Musa versus Malta, Raimi versus Greece, Raza versus Bulgaria, all cases related to countries from the south part of Europe. And this is not a coincidence. This is not a mere coincidence. Luled Massoud and Raimi acknowledged the primordial role of the necessity test in the application of the second limb of Article 5(1)(f) to the detention of asylum seekers, while Raza and Mikolenko, for instance, did so more generally with regard to the detention of migrants. The importance of the necessity test has also been affirmed in the application of the first limb when an individual has been detained pending the asylum assessment procedure. This was the situation in Suzo Musa. In view of the silent revolt of the chambers, the big challenge for the Grand Chamber is now to revisit and reverse the Saadi approach, as well as the A and Others spillover effect. And finally, all that the detention of asylum seekers is, as a matter of principle, a measure of last resort and may only be applied when no less intrusive alternative is possible, including in alleged terrorist cases. This will help bring coherence to the court's messy case law by aligning it with international human rights and refugee law. A number of international organizations, and instruments have repudiated the Saadi rationale, including the United Nations General Assembly, the European Parliament, the Court of Justice of the European Union, the Inter-American Court of Human Rights, and the Inter-American Commission of Human Rights. All of these bodies and courts have stated clearly that they do not accept this Saadi approach. The court cannot, the European court cannot remain deaf to the worldwide call that Saadi must go. Unfortunately, that was not the position of the Grand Chamber in recent cases. On the contrary, there is a clear trend to reverse the court's traditional refugee and asylum seeker friendly case law. And I will mention only three cases: Elias and Hamed versus Hungary, ND and MT versus Spain, and MN and Others versus Belgium. I'm going to refer to you the first case, which is related, directly related to detention of asylum seekers. In Elias and Hamed versus Hungary, the Grand Chamber evaluated the situation of migrants detained in a transit zone on the border between Hungary and Serbia. Quite rightly, the court restated that Article 3 of the Convention could only be meaningfully upheld by means of a legal procedure involving a detailed examination of the merits of asylum applications, even if later on the asylum claims proved to be unfounded. But migration detention centers were travestied as transit zones, so-called transit zones, where Article 5 of the Convention was not applicable. And this is very regrettable. The strategy of resorting to doublespeak, such as labeling migration centers as foreign admission and accommodation centers, or transit zones, or guest houses, now as the full consent of the court, of the Grand Chamber of the court. In the specific circumstances of the Hungarian case, this diversion technique, this diversion strategy was pursued at the cost of basic logic. Indeed, the judgment is blatantly contradictory, since when assessing the issue of detention, the court concluded, and rightly so, that Hungary had violated Article 3 on account of the lack of a rigorous assessment of the real risks the applicants were facing as a result of their expulsion to Serbia. But at the same time, it affirmed, in contradiction to the evidence available in the file, that the applicants were not being detained by Hungary for the purposes of Article 5 and could leave for Serbia in view of the lack of real risk in that country. In so doing, the court contradicted the unanimous findings of the Court of Justice of the European Union, the Council of Europe Committee for the Prevention of Torture, and the United Nations Working Group on Arbitrary Detention. All of these bodies and courts had stated clearly that the treatment of asylum seekers in this Hungarian transit zone at the European Union's transit border between Hungary and Serbia was indeed a form of detention. This self-inflicted international isolation of the European Court of Human Rights is incomprehensible. More importantly, by arguing that the applicants had entered Hungary voluntarily to seek asylum and were at liberty to leave the transit zone towards Serbia, the court not only put the blame of the situation on the complainants, implicitly criticizing asylum seekers for seeking to get out of their desperate situation, but also showed a great lack of sensitivity to the real situation leading people to seek asylum. For the court, Article 5 is inapplicable because the applicants can choose between liberty and the pursuit of a procedure ultimately aimed at sheltering them from the risk of exposure to treatment in breach of Article 3 of the Convention. This is simply intolerable. Let me quote the passage from the United Nations Working Group on Arbitrary Detention, which is quite telling of the reaction of a UN body on this position of the court. To put it in the words of the United Nations Working Group, and I'm quoting the working group, the working group cannot accept that an individual who must either agree to remain in the transit zones or lose the possibility of lodging an asylum application could be described as freely consenting to stay in the transit zone, end of quote. So you see that indeed the case law of the court has entered, I would say, a field where it can no longer be accepted. This narrow-minded way of interpreting the concept of detention under Article 5 can really not be tolerated. The court has failed to extend basic fundamental rights to migrants. In doing so, the court has turned its back to the most vulnerable and has failed to live up to its mission to protect human rights for all individuals. The court has allowed itself to be involved in the politics of migration, often forgiving states for buckling under pressure, but failing to consider the individuals at the other end of those sweeping, very populist, I would say, solutions. Politicians and politics may use excuses to limit rights when things get tough, but it is for the court to stand strong in the face of uncertain times and unexpected world events. It is in those times that the most vulnerable in our society suffer first and suffer most. It is our job, the judge's job, to keep the court as the shining light of human rights in Europe and across the world, to be the voice of the voiceless, especially in trying times. It has not done so recently, unfortunately. So my final word is that the academics, the academic world has a special responsibility to react to this case law and to voice its concern with this case law, because it really enters into a slippery slope where no longer there are clear lines that should not be, red lines that should not be crossed. And that was indeed the case in Elias and Ahmed, and I could also cite ND and NT versus Spain, or the recent one, the most recent one case, the MN and others versus Belgium. All of these three recent, very recent Grand Chamber judgments in a row sought to reverse the court's traditional refugee and asylum seeker friendly case law, which is really unfortunate. So my invitation to you is really that you turn your attention to these issues and as much as possible voice your criticism with regard to this new, more recent case law. Thank you very much for your attention.
Thank you very much, Judge Albuquerque, for this critical assessment of the European Court of Human Rights relevant jurisprudence. Absolutely brilliant and thought-provoking. And I would have also a few things to add, but for a matter of time, I've seen also there are already some questions for our speakers. We will open the floor, as I said at the beginning, at the end. So please wait for the end of the second panel if you still have any questions. So we'll move directly to our third speaker in this fourth panel, Professor Elena Valentini. She's Associate Professor of Criminal Procedure at the University of Bologna, co-organizer of this event. She has published extensively in the field of criminal procedure, in particular on preventive detention and pretrial detention, as well as on the rights of detainees. She published a monographic volume about administrative detention of migrants, and recently co-authored an interdisciplinary textbook on migration law. Her presentation today will lay out the general features of immigration detention in Italy, seeking to give account of the various challenges raised by the different types of detention authorized by law. Professor Valentini, thank you again for having accepted our invitation. You may take the floor now.
Thank you. Thank you. I would like to thank you, the chairman, for the kind of presentation. And also let me say that it's a pleasure to be here with you discussing about such an interesting issue. I do admit that my English is not fluent. I will do my best. In my brief presentation, I will talk about some peculiar aspects of the Italian approach towards migrants' administrative detention. First of all, it's important to consider that for a long time, Italy has been mainly a country of immigrants. Incoming immigration has become relevant starting from the end of the 80s. And it's only in more recent times that it had reached impressive dimensions. This explains the delay in the implementation of administrative detention for migrants compared to what has happened in other legal systems. It was only in 1998 that administrative detention was regulated in Italy for the first time, whereas many other countries have a far more long-standing experience towards this institution. When administrative detention for migrants was enacted, many Italian scholars questioned its compatibility with the Italian Constitution. One of the arguments raised was precisely the fact that the Italian Constitution doesn't mention such type of detention. However, despite the doubts expressed by many scholars and also by a part of the public opinion, in 2001, the Constitutional Court stated that administrative detention is in line with the Constitution and is an available instrument for the management of migration flows. The main function of administrative detention, we know, is to protect state sovereignty, applying wartime typical patterns to the peacetime framework. In fact, by avoiding that migrants without papers go into hiding, administrative detention is aimed at ensuring effective repatriation. To that end, another instrument has been constantly employed also in Italy. Criminal law giving rise to the so-called crime migration strategy. For a while, the Italian approach towards illegal immigration has been based on the synergy between criminal and administrative detention, especially in the period between 2002 and 2011. However, after an important decision of the Court of Justice of the European Union, the 3D judgment delivered in 2011, the scope of the crime migration has considerably decreased in Italy. Today, in the Italian system, only the violation of the re-entry ban gives rise to a custodial sentence. On the contrary, the irregular entry and the irregular stay, which are statistically much more relevant, of course, are now punished with a monetary fine. This means that today in Italy, the main instrument of coercion of irregular migrants is administrative detention. Notwithstanding, the law employs the word trattenimento, which is the Italian word for withholding. This measure more often goes under the definition administrative immigration detention, detenzione amministrativa. Such a definition appears to be accurate for two reasons. First, because it refers to something which is administrative in nature and not criminal. Second, because it is the police, which is an administrative authority, to be in charge for the application of the measure. The leading role played by the police is in compliance with both the European Union law and the European Convention on Human Rights. However, it's an unusual solution within the Italian framework. In fact, the Italian system tends to avoid giving the police the power to deprive an individual of his right to liberty. Only in some exceptional cases, the police can exercise that power without obtaining a prior authorization from a judge in order to make an arrest, for example. In any case, however, the measure is temporary and must be submitted to a judge for validation. But this traditional suspicion over the police is completely set aside by immigration law. As I have mentioned, in this field, the decision to apply detention is a prerogative of the police, which perform it in the first place. Within this procedure, the role of the judge is one of ex post formal control. So judicial reviews is indeed very weak in terms of guarantees, because the foreigner is often not properly represented. For what concerns the decision on pre-removal detention, its task is assigned to a non-professional judge who offers fewer guarantees of independence from the police than the ordinary career judge. Moreover, judicial review is all too fast. Such a fast procedure makes the review not thorough enough. Finally, in the judicial review, the judge faces an either-or situation, since she can't modify the police decision, but can only confirm or annul it. She cannot choose whether to apply alternative and less restrictive measures, and cannot determine the duration of the measure to be lower than that established by law. As in other countries, also the Italian system provides for 3 different types of administrative detention for migrants. This is a usual trilogy in many legal systems: detention for the purpose of removal, detention of asylum seekers, and detention on arrival. Alongside these measures, we find others not foreseen by law. A first may be called offshore detention of migrants. This type of detention was, for example, provided in the context of the memorandum between Italy and Libya. This controversial agreement responds to a logic of externalization of borders, also providing for cooperation between Italy and Libya in the management of centers for migrants in Libya. Another case of de facto coercion is the one resulting from the so-called closed ports policy introduced by the former Minister of the Interior, Matteo Salvini. In fact, denying docking to safe harbors implies a possible restriction of the right to liberty of migrants, and also a possible violation of Article 3 of the European Convention on Human Rights. I will now focus only for the types of detention regulated by law. With regard to the pre-removal detention, the requirements for the application of detention are described by the law in a very imprecise and broad way. This gives wide discretion to the police, making it hard for the judge to decline to validate the measure. In particular, pre-removal detention provides for an analytical and extensive range of indicators of flight risk, potentially affecting almost all irregular foreigners present in Italy. But this gives rise to a paradox, since it creates a striking gap between the number of persons who, according to the law, should be interned in a custodial center and the very small number of places available within those centers, today about 1,000. This gap greatly amplifies the power of the police, who chooses who to intern and who not to intern in detention centers, and has induced the Italian government last December to adopt priority criteria in the application of pre-removal detention, giving priority to individuals who are considered dangerous and to those who may be likely removed. Originally, compared to the pre-removal one, the detention of asylum seekers was regulated with a more precise determination of the conditions to application. Since the asylum seeker is exercising a right, detention was at first reserved only to the person considered to be dangerous, because they have already been convicted of serious crime, or for persons whose return had already been ordered and who were suspected of having made a bogus application to avoid repatriation, or moreover, for well-identified flight risk cases. However, by a 2018 law promoted by the then Minister Salvini, the cases of flight risk have been drastically expanded. Today, we can say that it is therefore easier for the police to apply detention to the asylum seeker. And in sum, we can conclude that over the years, several laws have extended the scope of administrative detention in Italy, especially with reference to its application requirements. Turning to the issue of the maximum period of detention, the situation is more complex. This maximum duration has been regulated in various ways over the years, from the maximum of 30 days initially allowed in 1998 to the 18 months in force from 2011 to 2014. Currently, after a very recent law, the maximum period of detention is 90 days, both for the removal detention and for the detention of asylum seekers. The many amendments to the maximum length of administrative detention show the mainly symbolic value of this measure, also considering, this is very important, also considering that its actual impact is minimal in Italy. Indeed, despite the various types of detention potentially enforceable against a large number of migrants, only 1% of irregular foreigners are detained in immigration centers. One of the reasons for the current low impact of these measures is also the difficulty of the Italian state to provide adequate detention conditions. Detention centers are different and separate from prisons, but in practice they present much worse detention conditions which are not properly regulated by law. In this regard, however, it must be said that a piece of legislation approved a month ago introduced the possibility to activate a remedy in case of violation of fundamental rights, a remedy that was not previously provided for. In my opinion, it could be the effect of the European Court case law. I think in particular about the case Claifia versus Italy. Finally, a partially different issue concerns detention imposed on arrival. In this regard, it should be noted that for a long time, the Italian government refused to regulate in a proper way this form of detention, which is so important considering that Italy is an external border of the European Union. This refusal was due to the Italian resistance to fully comply with the Dublin regulation. As of 2017, a partial regulation has been introduced, but the current text is still inadequate to address its purpose and doesn't properly safeguard the rights of migrant newcomers. Thank you for your attention.
Many thanks, Professor Valentini, for your very interesting presentation on the challenges raised by the different types of detention against migrants in Italy. We are running a bit late, so I will just give the floor directly to Paolo Loba so we can start with the second panel. I would just to thank again the three speakers for the three amazing, absolutely inspiring presentation in this first panel. Thank you again. Paolo, the floor is yours.
Thank you, Tristino, and very good afternoon, and welcome you all to the second part of our webinar. Let me first of all thank all speakers for having accepted our invitation and participants in the audience for being here, though only virtually, of course. You can see from the program that this second panel is going to deal with immigration detention. While the first panel was mostly concerned with preventive detention at the international level, we will zoom in, addressing a number of more specific issues. Along the same lines of the talk given lastly by Professor Valentini, whom had to be relocated last minute to the first panel, two of our next speakers will give us instructive examples of how immigration detention works in their own countries. So, Mrs. Noreen Shah and Professor Mary Bosworth are going to provide some insights into the systems of the United States and the United Kingdom, respectively. In turn, Judge Professor Ksenia Turkovic, who will should reach us shortly. She excuses her, but she's engaged currently in the section important meetings. The judge is going to expand on the notion of immigration detention in the context of transit zones. Following Tristino's prompt, I'd like to remind our panelists that they have a maximum of 15 minutes for their presentation. But now, without any further ado, let me introduce you the first panelist. Ms. Noreen Shah is a Senior Advocacy and Policy Counsel at the American Civil Liberties Union. Her civic engagement has lastly focused on immigration detention and refugee issues. She carried on-site visits to immigration detention facilities across the US, where she witnessed the conditions of detention of migrants and had the chance to conduct interviews. In her capacity of an active advocate for human rights, she has appeared on several TV and radio outlets and has published a wide array of blog posts. She's going to give us a presentation on the United States system of immigration detention. Now, Mrs. Shah, thank you again for being here, and I'd like to hand over it to you.
Thank you so much, and thank you for the opportunity to meet with you all today and to talk about immigration detention in the United States. So just as a way of introducing myself further, thank you very much for that kind introduction. I am a practitioner, and my role at the American Civil Liberties Union, the ACLU, is as an advocate. And this is a really important time for us in the United States because we have a new administration and we're very hopeful about seeing some serious changes. But we also have a very divided country. So I'd say it's a time of torment and trouble in this country. And I'm speaking to you today about some of the issues that have very much roiled this nation to do with immigrants, because immigration is so much a political issue in the United States. And the treatment of immigrants in detention is at once something people don't understand and something that people debate because it falls very much on conservative, liberal, or right-left lines here, as it does in so many countries. But top of mind for me as a lobbyist in the United States is what we can actually get the Biden-Harris new presidential administration to do. So maybe I can just begin by giving you an overview of what immigration detention looks like in the United States. And I'll talk about two systems of immigration detention, one by Immigration's Customs and Enforcement, which is detention of people in the interior of the United States, and the other is Customs and Border Protection, which is detention at the border of at the United States. It's certainly the southern border is more the focus of that. And then I'll tell you about some of the things that we're asking the new Biden administration to do. So overall, to give you a sense of the scale of it in the United States, in the summer of 2019, on an average day, you would have had about 85,000 adults and children in some form of immigration detention in the United States. And that the network of immigration detention in the United States includes border holding facilities run by this agency, Customs and Border Protection, known as CBP. It also included warehouse-sized shelters for children. And finally, it included a network of more than 200 jails and prisons operated in states all around the country under contract with Immigration and Customs Enforcement, known as ICE. So these are all different agencies in the US government that are running immigration detention, and they have different cultures and practices and responsibilities. What they have in common is that they use immigration detention to deter people from coming to the United States, to punish people who come to the United States, including people who are asylum seekers. So today I want to focus on adult detention. So it's detention of children with their parents or just of adults. So I want to start by talking about ICE detention, that's Immigrations and Customs Enforcement. We use the abbreviation ICE in the United States. And you may have heard of something called the Abolish ICE movement. There's been a lot of controversy around this agency. So ICE holds people for the longest. They hold them for months or even years. And they hold tens of thousands of people. At the peak in 2019, they were holding about 57,000 people a day. We're talking about maybe 300,000 to 400,000 people in a given year. What we know is that over several years, there's been documentation by physicians, journalists, advocates, whistleblowers in the United States. They've established that this detention system under ICE is rife with abuse, medical neglect, and dangerous conditions, and the problem has only grown worse under the COVID-19 pandemic. In the past year, the death toll in ICE detention has reached levels not seen in 15 years, and we've seen the use of force, including pepper spray, physical force, rubber bullets, has increased. Vulnerable immigrants are being subjected to coercive medical procedures, including hysterectomies and other procedures that damage reproductive capacity. And the lack of medical and mental health care that we've always seen in ICE detention has resulted in serious harm, including the loss of hearing and sight, amputations, and suicides. Detained people in the United States cannot get access to prescribed medications, medical tests, or treatment for serious conditions such as HIV and diabetes. Medical staff routinely provide only the most basic of medications like a tube of anti-itch cream, a few aspirin, and that may be all that they get, even when they have a very serious medical condition. With COVID-19, we've seen the ultimate costs of these kinds of failures. The agencies involved are ignoring public health recommendations. They've refused to test detained people. They knowingly transfer people between detention facilities, between outbreaks, which contributes to even further outbreaks of COVID-19. They've refused to release substantial numbers of people, even though they're not able to create humane and safe conditions for them. There's an NGO in the United States called Freedom for Immigrants, and they are providing a monthly analysis and updates on COVID-19 in U.S. immigration detention. Last week, they issued a report expressing concern about ICE's use of what they call cohorting, in which groups of people who are suspected of having been exposed to COVID-19 are detained together. So you have people who've tested negative and people who test positive who are being forced to stay together, which increases the risk to those who haven't actually tested positive yet. In other cases, we see prolonged solitary confinement as a way of medical quarantining. But what we know is that people are being held in that solitary confinement for extremely long periods. And as conditions continue to deteriorate in immigration detention, people who are held there expressing quite a lot of desperation about their lack of access to soap, lack of access to face masks and personal hygiene products in filthy conditions. Facilities are not being cleaned. And people who are in ICE detention continue to report that basic public health protocols are not being followed. They fear that the facility staff who work at these facilities are actually bringing COVID-19 into detention because so many of these facilities are in communities that are suffering due to the pandemic. As of January 13th, in this form of immigration detention by ICE, we had 8,820 positive cases confirmed across 118 different prisons and jails. So, I've talked a little bit about COVID-19 in immigration detention. Even before COVID-19, even before the pandemic, what we knew is that this system of mass incarceration of immigrants in the United States was not necessary. Most people in immigration detention in the United States are locked up pending their deportation or removal proceedings is the term we use here, which means they haven't been ordered by a court deported. In fact, they may actually have the legal right to remain in the United States. And many people will languish in detention for months or years for no reason, only to actually win their cases. And this is a fundamental flaw in the US immigration detention system. It denies liberty to tens of thousands of immigrants without regard for their individual characteristics or the availability of less restrictive alternatives to detention. So we have thousands of individuals, including asylum seekers, who are denied release without the government ever having to justify their imprisonment at all. That's in violation of their rights to due process under the Fifth Amendment of the US Constitution, and of course, their rights under the ICCPR, which the US signed and ratified. Other people in immigration detention are found eligible for release as they await for their immigration, as they go through their proceedings, but they are still detained. And the reason they're detained is because they don't have money to pay for a bond. So it's a lack of financial resources that is resulting in people remaining in detention even though they are eligible for release. In the US, our Constitution and under our system, liberty is the norm and detention without trial is supposed to be a carefully limited exception. So from the perspective of the organization that I work for, the American Civil Liberties Union, the government should be operating under a presumption of liberty for everyone who is in immigration detention. And government policies and practices should reflect that alternatives to detention will generally be sufficient to address the government's interest, which here the government says that the reason they're detaining people is to put into effect a final order of removal. So they say they're only detaining people for the purposes of facilitating their deportation. We believe that there are many other ways to ensure that people go through their immigration proceedings, including providing people access to counsel, which we don't have as a right for immigrants in this country. So as we look to the Biden-Harris administration, the kinds of things that my organization is asking for is, first, we're asking for them to close a large number of facilities. About 81% of these facilities are run by private prison corporations. They've made a huge amount of money off the Trump administration's anti-immigrant policies. And what we're asking the Biden-Harris administration to do is to end those private prison contracts, because people shouldn't be making money off of this human misery. And we think that a number of the horrific conditions that I have described can also be attributed in some ways to the fact that we have private prison companies that are trying to maximize their profits at the expense of humane detention conditions. We're also asking the Biden-Harris administration to conduct a file review to look at basically every individual's case and make an assessment of whether or not there is a basis for release. We are again arguing that there should be a presumption in favor of release. And finally, we're asking the Biden-Harris administration to address the inhumane conditions of detention, including banning the use of solitary confinement and banning force feeding of people who are conducting hunger strikes. I also, what I've been talking about so far is ICE detention. ICE, again, is Immigration, Customs, and Enforcement, and that's detention that happens to people who are already in the United States and who've been going through the process. It's very lengthy detention. Now I want to turn to talking about Customs and Border Protection detention. So this is more akin to, border camps, border detention facilities that exist in other parts of the world. In the United States, Customs and Border Protection, their acronym is CBP, is the largest federal law enforcement agency with a budget of more than $17.1 billion. They have an Air Force, they've got intelligence operations, but their role is protecting the border. And unfortunately, that also means that they take custody of individuals and they detain them. This is an agency I wanted to talk about with all of you because I think it's so important that people understand that it is at the heart of the greatest moral horrors that we've seen in this country over the last 4 years, some of them. This is an agency that was separating families. So we think about the sounds of children sobbing that were recorded when they were separated from their parents at the border. The little girl, I don't know if you all saw the photo of a little girl with her arm around her father's neck. They were desperately holding on to each other as they drowned, attempting to cross the Rio Grande River at the Texas border. Count the images that really shook this nation in 2019 of countless human beings trapped in open air cages and indoor cells so crowded that the people in them were pressing their hands to the window, desperately pleading for help, silently pleading for help as the news cameras flashed. This is the agency that conducted these abuses. And we're at this moment of reckoning where it could be that we continue to rely on this agency in this country. So, you know, one of the special rapporteur who spoke earlier spoke about Guantanamo. And one thing that strikes me as a person who worked on both Guantanamo and torture by the CIA and who now works on this is that although Guantanamo remains open and there are, you know, 40 people there and it is horrific, at least there was a reckoning in this country with the torture that happened at CIA black sites. And there was a decision not to try to, you know, to avoid that again. But when it comes to immigration detention, the agencies that have conducted horrific abuses are poised to continue to operate with impunity, even under the Biden-Harris administration, because we haven't had a reckoning with their practice and their culture of abuse. So I only have a few more minutes, but I do just want to tell you a little bit more about those abuses. Hundreds of thousands of people are held in these holding facilities at the US-Mexico border every year. And they're detained while their asylum claims are being adjudicated for a period of time. Often they're held in facilities known as hieleras. That's Spanish for freezers or ice boxes. They're typically small concrete rooms with no beds, no showers. People sleep on mats. They endure these freezing conditions, inedible food, insufficient potable water, overcrowding. The organization that I work for documented people being held in situations of sleep deprivation over multiple days. We also documented in February of last year, a woman being forced to give birth to her baby while standing up, holding onto the side of a trash can in one of these Border Patrol stations. And we've documented patterns of abuse of pregnant people across this agency. So in light of the horrific conditions that I've described, we have argued that this agency is categorically unsuitable for the detention of vulnerable people. But I will note that as we've seen international agencies and NGOs internationally be consulted about what the United States should do with people who are coming at the borders, a model for welcome reception centers, humanitarian reception centers. What we haven't seen enough, I think, is a reckoning with this particular agency and an urge that the US government never allow this agency to detain people under any model of asylum or refugee protection. That is what the organization that I work for, the ACLU, is urging. And I hope that is a recommendation that can be echoed by advocates across the world. Thanks very much.
Thank you very much, Ms. Shah, for having described in such a detailed and direct way the conditions of detained migrants in the United States, as well as the impact of policies put in place by the previous federal administration. I think it would be crucial to keep the pressure high on the new Biden administration so that the topic of reforming the legal pressure to reforming legal regime and practical conditions of immigration detention remains priority. Now, our next speaker, Judge Turkovic, has just informed us that she still needs some time at the court before joining us. So there is a small change of program, and we will give the floor first to Professor Mary Bosworth. Professor Bosworth is director of the Center for Criminology at the University of Oxford. It is hardly an understatement to say that she's one of the leading scholars worldwide as regards immigration detention. She conducted groundbreaking field research in immigration removal centers. Her extensive work exposed the pretense underlying the distinction between administrative detention and criminal punishment. Her talk is going to sketch out the system of immigration detention in the UK and brief us on the impact of the COVID pandemic. Professor Bosworth, the floor is yours. Thank you.
Thank you, Paolo. And thank you, Noreen, for that extremely distressing presentation about the US. It's always horrifying to hear about what happens in America. I have a PowerPoint presentation, and now it's coming up. I apologize about being such a criminologist that I will always use PowerPoint, but I would like to just share with you some images and some testimonies from the people in detention who I've spoken to over the years. Do I just say next slide, I guess? So here on this slide, I've just sort of noted down the basic outline of the system in Britain. And I would say that it's a complicated time to be giving a presentation about immigration detention in the United Kingdom, because it's very much a system in flux. And you know, to give you a kind of comparative sense, the numbers in detention have actually been declining really since about 2014, 2015, because there's been a lot of activism. There's been a lot of work also from within the Home Office around the Immigration Detention Centre. And so before the pandemic, the numbers had declined to about 2,600 people from a high in per day, from a high in 2014 of around 4,000. So obviously relative to the US system, as the prison systems are too, much, much smaller. And under the conditions of the pandemic, the numbers have gone down even further. So at the moment, I believe there are around about 700 people in detention in April. So when the pandemic first began, that number actually dipped all the way down to 350. So on one level, there's actually, I think, a real possibility that we could be imagining a sort of an end to the system and something totally different could come out of the pandemic. Having said that, as I'll go on to show, you know, maybe I'm not quite that optimistic, but anyway, currently there are 7 immigration removal centres, and there are, in addition, there are more than 30 short-term holding units. And traditionally, those two kinds of places have been analysed quite independently, and actually nobody's really done much work, if any, inside the short-term holding facilities. Before the pandemic, I had begun a project that included them, and I've been to a few of them even during the pandemic. But one of the things that is happening is that they're being pressed into service actually in new ways, partly because of the slightly different way in which the system is being used at the moment. Also in the past, the population was very diverse in immigration removal centres in the UK. So it has always included people with criminal convictions and failed asylum seekers, and some people whose asylum claim is underway, but who fall into various categories where they can be detained. but it also included lots of people who were just there for very routine immigration matters. So people who overstayed their visas, people who never had a visa, people who violated the terms of their visa. And one of the things that has happened under the pandemic is those sort of immigration cases have really been stripped out. And there are really now primarily just 2 populations who are being detained in the UK. One are not just ex-offenders, but ex-prisoners, so people who are being moved into removal centres from prisons. And then the other is this specific group of asylum seekers who are the people who've come over on small boats from France and who've come through Dover. And I think in these 2 populations, you see quite clearly the role of detention in the UK, which is as an add-on to the criminal justice system, which is, you know, what initially activated my interest in it as a criminologist, and then a return, if you like, to it being used in the asylum process. Because although that never completely fell away, it had significantly reduced. And now for this population, at any rate, it's been very important. Most people in detention, as a result of the sort of focus on these 2 populations, most people in detention are there awaiting deportation or administrative removal. There's still, you know, some of these asylum seekers, it might be used as a time for identification, but really they're being placed in confinement in order for the British government to be able to remove them. As I'm sure you're all familiar, the British system is marked out by the lack of statutory time limit other than for pregnant women and families. And so even before we exited the EU, we had no time limit. And also it's marked out by the fact that it's a wholly contracted out system. So all of the detention centres are run either by private sector security companies, or there is one remaining one that's run by the prison service. They all run them on behalf of the Home Office. In the British system, the immigration removal centres are also very much marked by a connection to the prison system, both architecturally, as I'll show you in a moment with some photographs, but also in terms of personnel. So all centre managers are former prison governors. The detention centre rules are modelled on the prison rules. They are inspected by the Her Majesty's Inspectorate of Prisons, and they have resident, or they normally have resident, this has actually largely been suspended under the pandemic, but they normally had the Independent Monitoring Board, who also are present in prisons as well. They are sites which are notwithstanding this long-term connection to the prison system, they are sites which are quite sort of reactive, and like the American ones, it's very clear that immigration detention is a political matter. So populations go up and down. The constitution of the population in terms of, you know, which nationalities there are more of, that also changes quite rapidly. They are always in a bit of a system of flux, but I would say really since, certainly since 2016, since the first Shaw Review, they've been even more, undergoing even more transformations, and this has just escalated under the COVID pandemic. So we can move on to the next slide. This just gives you a sense of what immigration removal centres look like in the UK, and down what is for me the left-hand side of the page, where there are 6 images. One, the little one is a map which shows you how they're distributed, the 7 if your eyesight is good enough. And the other ones all show you really how much they look like prisons. So these are particularly the top left-hand and bottom right-hand image. These are buildings which are literally designed as high security prisons. Men in them are held behind metal doors in cells, 2 people to a cell, although they call them rooms. You know, there's suicide netting in the kind of to stop people jumping down and killing themselves inside the housing units. They also have small exercise areas. Officers wear uniforms, they carry keys. These are very much designed around prisons. On the right-hand side, you see the kind of alternative sites, which are the bottom 2 are both in Dover. So the shipping container is where people are taken when they come off the boats, and that's the first screening site where they're screened by Border Force, by the Home Office, and then they're kind of parcelled out. And so women and children and families go to the middle room with the blue chairs. That's the Kent intake unit. And then from there, they are sent to various places. The picture with the barbed wire is one of the sites which the government pressed into service, which I understand actually they've now had to mainly move people out of, because this was a former military camp which was not kept in particularly good repair, and they put hundreds of people there who had not been screened for COVID, and lo and behold, they had a huge outbreak with more than 100 cases, and they've now had to move people. I saw just before I came on, people are being moved to hotels. But you can see there's an array of different sorts of sites. The short-term holding facilities are designed, as you can see by the chairs, to really be only for very brief periods of time, for less than 12 hours, although increasingly people are actually held beyond that, partly because the system doesn't quite have the capacity, either in terms of rooms, but also in terms of vans to move people around. So the next slide, please. This is just a picture of books I've written. This is just, I've been studying these sites since 2009. I've done all sorts of research inside them. I'm not a lawyer, so my work is all qualitative and involves observations and interviews, and in the case of the archive, artwork as well. So the next slide. what I thought I would do, and I'm not going to read all of these because I'm conscious of the time, I thought I would first of all just run through the kinds of things people report fairly frequently about their experiences of detention. And so these quotes were all taken from people who I spoke to before the pandemic. And you can organize them under various sort of key issues that are human rights issues in terms of access to healthcare and family life and things like that. So here you can see in these quotes somebody talking about the enduring problems that people encounter in detention of accessing human rights protection. So Rule 35 is meant to be, as everybody presumably will know, it's the process by which you can be certified as a rape or a torture victim, or sorry, as a torture victim, and then that is meant to activate pardon me, a response which makes the threshold for holding you in detention higher. You count as a particularly vulnerable person, and it would help release. And so this man was talking to me in Harmondsworth, which is one of the detention centres near Heathrow, and he was saying that he'd been brought in to one detention centre, I believe it was Morton Hall. He'd waited for 2 weeks for an appointment, and then just before he was due his appointment, he was then transferred to Harmondsworth, where he actually had to wait another 6 weeks. And so by the time we saw him, he still hadn't ever had this appointment. In addition to that kind of account, it would be almost ubiquitous to hear people talking about the sorts of issues that the second quote is around: breathing difficulties, anxiety, agitation, memory loss, depression, suicidal thoughts, loss of appetite. So the sort of way in which people in detention, no matter how they are when they come in after a period of detention, express all sorts of medical and particularly mental health problems, and we have a lot of documented evidence of that. Next slide, please. So people talk a lot about the impact of immigration detention on their right to family life. So here again are just a series of quotes that people have said around the pains of detention, how detention separates them from their children, that the process of detention breaks their family up, and that for many of them in the United Kingdom, these are people who've actually lived in the UK often since childhood, and they are therefore they will have not just a girlfriend or a husband, but they might have uncles and aunts and even parents and grandparents. So it's not this sort of version of who a detainee is in the UK is very much the case for people who've been in prison, that their criminal offence will have made it more difficult for them to obtain citizenship, and so they may often be the only person in their family who did not regularise their status, and then they are sitting in a detention centre waiting to be deported back somewhere where they have not lived since perhaps being a child. Next slide, please. And then finally, people talk very often in these sorts of terms around the question of whether or not whether they are being treated as people. And so it's very easy to find quotes like this in all sorts of reports, in all sorts of academic articles. People in detention feel that they are not treated as human beings, that they're treated as animals. They're treated as dogs. There's all sorts of metaphors that people use. Sometimes there are more specific ones around, how they can't express certain parts of their identity. So being gay in detention, and that in that particular quote, that's not necessarily because the officers are going to be doing anything about that. That might actually be that other detainees are homophobic. So that there's all sorts of ways in which people feel that their essence of who they are is denied to them in detention. And one of the key driving factors of that is how people in detention often feel that they are being treated like criminals. So the design of the buildings that I showed you before is not lost on people who are detained. They feel as though they're treated that they have been placed in a prison, even if they have not committed a criminal offence. Next slide, please. So obviously human rights protections offer some promise as ways of addressing these sorts of pains of detention, and it is certainly, I think, important to acknowledge that immigration removal centres in the United Kingdom do not suffer from the kinds of egregious examples of abuse that we've just heard about in the US. They are inspected, they do meet human rights standards by and large, I mean, and in important ways. They are not sites outside the law. And they are also sites which are supported by visitor groups, and there's a very active civil society sort of group around detention centres, including people who have formerly been detained. However, there are also, I think, lots of factors which make it very difficult for people to avail themselves of these rights protections. So they range from just overall hardening of borders to the criminalisation of lots of aspects of migration, which is then balanced against their rights. The lack of a time limit in the UK is particularly difficult. And so there are, fundamental questions about whether or not people actually can avail themselves of the rights and of their protections, and therefore do they actually really have them? And these are massively compounded by the lack of legal aid, which has been documented by Anna Lindley from SOAS. So there's a huge problem of concrete versus abstract rights. These are sites which are protected, but it's very hard to get them. And these issues have been compounded by the pandemic. So next slide, please. So there's been a lot of effects of the pandemic. Some of them have been, I think, reasonably positive. If you're imagining that we're trying to, that you want to work towards a smaller system or no system at all, and obviously some of which have been very negative. So the most obvious one I've already mentioned, which is that the population has significantly decreased, and also that deportations have either been paused. They were paused in sort of March and April. They did restart, but now they are largely paused again. There have been other kind of less visible effects. So although the HMIP still inspects these sites for in order sort of to protect human rights, their methodology has had to change. So they have to be much briefer. They can't spend as long there because of the health risks. The IMB have a much more limited presence now. So the IMB is a group of volunteers, and they tend to be older. So they're often going to be in the population of people who'd be particularly at risk if they caught COVID. And then there've been changes within the centres themselves. So the population, as I've said, has kind of fallen really into these two groups of ex-prisoners and recently arrived asylum seekers. There's, practical things, PPEs more available inside. The UK also uses a cohorting system. So once somebody has a positive case, anybody who's been in contact with them, they're grouped together. There's a very complicated distribution of people around the system, which can mean people are sent very far away from their families. They've pressed into use short-term holding facilities. They have totally transformed the women's detention centre. So Yarlswood used to just be for women. There are almost no women at all in detention in the UK at the moment, other than people who arrived on the boats from France. Yarlswood has become a short-term holding facility mainly. There's been a greater use of single occupancy rooms. So some of those things are good, some of those things are bad. And then there's been this emerging and I think very troubling case of a whole new system, which we need to be paying a lot of close attention to, which is this whole new system of asylum seeker camps. And the UK, of course, used to have those, then got rid of them, hasn't had them for a very long time, and now they're back, and they've kind of just come back in a flash without really much contestation. I mean, obviously, civil society has been contesting them, but the general public does not seem to mind too much. The next slide, which I think is the last one. Sorry, I've probably gone over time. So just to conclude, I think that there are reasons to be positive or optimistic, and there are also reasons to be very concerned at the moment. So as ever, I think that it's important for us to remain very conscious of how border control has a potential to undermine rights for everybody, and that therefore there's a need for a lot of alliances across, you know, practitioners, academics, civil society, sociologists, criminologists, lawyers, all of us. I think that the pandemic has highlighted these connections with the criminal justice system, which I think people are aware of, but probably needs more work done, and challenge, you know, raises specific challenges for activists. It has also shown the kind of enduring suspicion of asylum seekers, so that even though the people who come across on the boats, relatively speaking, are very small in number, and obviously are very desperate, there has been a lot of public, you know, it hasn't been too hard to whip up public sentiment against them. I think there has been a recognition here, much more so in the US, for instance, of detention as a crucible for contagion of the virus, and that opened doors that were previously completely closed, literally as well as metaphorically. And so COVID has offered some opportunities for decarceration, activism and engagement with questions of public health. And we saw this in 2016 also, when there was a lot of attention and concern about mental health following the Shaw Review. The response to mental health was to kind of devise a system which supposedly screened people out but screened people in. So we have to be aware of that the bureaucratic responses to public health can sometimes just perpetuate the system. But I think one area where this is a bit different is that COVID doesn't just affect the people who are detained, it also affects the people who work with people who are detained, and it affects their family. So there is an opportunity, I think, also to perhaps try and work alongside or with guards, keeping in mind that they are by and large not like the kinds of guards we just heard about in the US, and that actually this public health issue is one that affects them and the community in which they live, i.e. all of us, as well as people in detention. Thank you.
On behalf of everyone here, I wish to thank you, Professor, for most thought-provoking and, I must say, at times troubling talk. Before moving on to the Q&A session, please let me share a few closing remarks with you. Unfortunately, Judge Turkovic did not make to join the seminar tonight. She apologizes with all of us, and especially you in the audience. So turning to the closing remarks, this last bird's-eye view across 3 continents and 3 countries left us strikingly similar picture of the reality faced by detained migrants. And I just would like to draw your attention to 4 common points that I think have come to the forefront. First, the conditions of detention are dreadful, a bit everywhere. Migrants are more often than not detained in a state of neglect, lack of proper care, and chronic overcrowding. Second point is that provisions regulating administrative detention are vague and far-reaching. In other words, authorities are placed under minimal constraints. Just let us mention a few examples. There are broad clauses that allow or mandate detention, a wide discretion vested in the executive. There is a lack of statutory ceiling on the length of detention, or anyway, a rather lengthy duration of detention. And detention is envisaged as the default option, not there's no legal duty to consider alternatives before resorting to detention. The third common element is that procedural safeguards are generally substandard. Let us just mention a very limited judicial review, as our speakers mentioned, limited to non-existent opportunity, in effect, to challenge the legality of the detention order, ineffective representation, and lack of individual assessment. But the final and perhaps most unexpected element, a common element, is an approach that I would call of laissez-faire on the part of the judiciary. It is as if judges feel that the issues surrounding immigration detention are so politically charged and divisive that they fall entirely within the province of the political realm. This overall framework resembles closely the regime of preventing detention against suspected terrorists. in particular, as long as courts allow it to continue indefinitely, as long as the war on terror goes on, which so far sees no end in sight. This largely unregulated area, this legal limbo, stands in stark contrast not only to the usual range of safeguards in criminal proceedings, but also with a traditional assumption grounded in human rights law that the right to liberty is one of the highest importance in a democratic society. So the impression is that authorities exploit immigration detention to pursue goals that have little to do with migration management, but are closer to social control. The privation of liberty appears to be aimed less at preventing flight than at responding to perceived social dangerousness of migrants or terrorists, suspected terrorists. Preventive detention becomes in this way a tool to define the boundary between social inclusion and social exclusion. This effect is no different from the one produced by the actual functioning of the criminal justice system, as criminologists have posited. The huge difference, however, is that in the implementation of administrative detention, the government is left with practically unfettered discretion, given that legal constraints and judicial supervision are lax, to say the least. Migrants, as well as other internees, navigate through a territory devoid of firm reference points. So it is against this backdrop that we, scholars, practitioners, activists, we have to reflect on how to reclaim this domain, how to bring it back under the protection of law. We should remind ourselves that it's taken centuries to erect some safeguards into criminal law. And even nowadays, the system appears broken in many respects. So it's not surprising that the strategy concerning preventive detention has to be one to be acted upon in the long run and implemented in multiple stages. The starting point, I think, of our reflection is that soft law is far more advanced than hard law, hardly surprising. Suffice it to recall the various pronouncements of the UN Working Group of Arbitrary Detention and the extensive work of the UN Special Rapporteurs. As for hard law, as we have seen, domestic courts seem reluctant to adopt a more progressive position towards detainees' rights. In turn, the Global Compact for Migration is still quite far from accomplishing its declared goals. So it appears natural to place our hope in international courts. First of all, the European Court of Human Rights, that despite all the weaknesses that have been highlighted by Judge Albuquerque, for example, in his talk, still remains the first port of call for several reasons. So the first obvious is that the court's judgment binds, in effect, 47 states and 800 million people. Secondly, the court's case law may transpose part of the said soft law into binding principles. But most importantly, the court has already developed a set of principles whose reach could arguably be expanded to cover immigration detention too. So under Article 5 on the right of liberty, for example, the court established a firm case law mandating that certain forms of administrative detention may not have punitive character, but also that the importance of attaining the goal that detention pursues must be balanced against the importance of the right of the right to liberty. So, depending on the nature of the purpose of detention, the court imposes strict limits on both the degree of the restriction, on its practical conditions, and on its length. Turning to Article 7 of the Convention, for example, or no retroactivity of criminal law, the court has already qualified certain types of preventive detention, for example, detention for mentally ill persons, as a criminal punishment when its main purpose was found to be punitive. So in conclusion, there are principles that appear to be directly and immediately applicable to preventive detention as a whole. If politics is unable to act, it is for the courts, reclaiming their role of ultimate protectors of human dignity, to apply those principles. But this operation would be facilitated if awareness grows within the academic community and civil society around those topics. And that's why Triestino and I, that's what we would like to do through the creation of the interest group Beyond Detention. As Triestino said at the beginning, we'd be happy to receive expressions of interest from those who might be willing to join the group. Now, if someone is still awake after this talk and after this very engaging webinar, I would like to open the panel up to questions. I'm sure that after those stimulating presentations, you would like to ask a question or make a comment. For those who wish to come forward, you should click on the button to raise your hand. It's on the chat panel of the Zoom application. Please try to keep your questions brief, it's possible, so that we can maximize the number of people who have the chance to ask a question. I see that there are 2 hands raised. So I see that Maria Giulia Giuffre would like to take the floor. She's an expert in migration law and author of a recent book on the readmission of asylum seekers under international law. I will try to activate her microphone. She's not there anymore.
Yeah.
Okay, then here she is. That's great. Perfect. Thank you.
Thank you so much for your inspiring presentation. Very, very informative. I have a question for Professor Bosworth. I'd like to ask how you would assess the use of alternatives to detention in the UK, but any other insights or on other countries would be very interesting. And I'm wondering what your view is on the success or failure of alternatives to detention. And as a separate question, so what you think is the impact of such less coercive measures on the mental health of migrants? Thank you.
Thank you. So I mean, of course, in the United Kingdom, almost everybody is in some kind of alternative because actually detention isn't used that much. And normally, before the pandemic, normally people were put into reporting requirements, and that was the most common way in which people are managed. Actually, during the pandemic, even that was not used. So you know, people were released and they were not put into anything because there was nothing working because of concerns about, pardon me, about the virus. I did a literature review on alternatives to detention for the second Shaw Review in 2018, and I haven't done really work on it since then. At that point, the main bits that came from the literature were that there's lots of programs which haven't been evaluated, and the ones that have are generally from quite some time ago, and actually normally in the US. And what they normally show are the things you would want them to show, which is that they can be very effective, that they work best if they are include all sorts of access to health and education and kind of training and all of the rest of it. I personally think that there's a slight risk about the discourse on alternatives to detention, which is what has happened in the criminal justice system with alternatives to prison. Namely, that systems quite often happily introduce things that seem to be slightly less coercive without actually rolling back the system that this was a response to. So it seems to me that we should and could push for alternatives, but only if it was not as an add-on, but as a complete end to custody. Because without that, I think really what you end up doing is you just draw in people who otherwise the state would have simply just kind of let tick over and not had much interest in. There's also evidence around specific alternatives which states like to use because they're efficient and effective, and they also lend themselves to partnerships with existing private companies, namely electronic monitoring. And there is evidence about that which shows that that's actually very dehumanizing and has many of the same kinds of effects on mental health that custody has. So I think people need to be very careful about advocating for alternatives, because I think it can end up in situations which are not what people are hoping for.
Thank you, Professor. Thank you for your answer. And I see that we have a question from Rosanna Cavallo, that she raised her hand. And if you could please state your affiliation before you pose the question. Thank you so much. Ms. Cavallo, you can activate your microphone. It appears that there are some technical issues. In the case that Rosanna Cavallo is not able to connect, we may go forward to the question by Peter Langford. You may go ahead. Thank you.
Hello, I have a question for Professor Iolan, which is about the Convention on Civil and Political Rights, and in particular, general comments on Article 9, the right to liberty, and general comment on Article 14, which is the right to fair trial. And what I wanted to ask was how far you consider the normative principles in both these general reports as actually providing a fairly strong impetus against the types of developments and let's say intersections between administrative and criminal law, which you traced in your talk.
Thank you. Really, really good question. Do you want me to answer it? I'll proceed? Yes.
Yes,
so
thank you.
I think, so as a formal matter, it seems to me, and I would need to reread them both closely with your question in mind, so I'm going to answer this without, in this way. I think as a formal matter, neither of them give full consideration to the kinds of sequence of developments and overlaps that I have identified as patterns and trends in my thought. So if we, for example, compare both of those general comments with the revision of the general comment by the Human Rights Committee on Article 2 of the Convention, which was published just, I think, about a year ago, or the more recent general comment on freedom of association, we see, I think, some gaps just in terms of like the capacity to keep pace or re-articulate how the norms would be understood as both the right to liberty and the right to fair trial have been impinged upon in different ways by the intersection of other legal systems. So I think the committee is aware of that. That's separate to the question, I think, more broadly as to whether the general comment operates as a sufficient kind of pushback against some of the other developments that we're seeing that push against its normative content. And I think that I just want to speak from the security and counterterrorism space. I think we see really significant pushback, and I mean normative pushback, coming against human rights norms more generally from the security and counterterrorism arena. And here I want to reference the sort of tsunami of soft law developments that we have seen in the counterterrorism arena. Those soft law normative standards are being produced not only by the global counterterrorism architecture, which comprises the Security Council, the Counterterrorism Committee, and the increasingly, I think, problematic interpretive role being played by UN CTED, the interpretive body for the Counterterrorism Committee. but also the normative content being generated by the Global Counterterrorism Compact, which is made up of 8 working groups, which is busily producing guidelines, normative frameworks, principles, advice to states. And on top of that, we've had the establishment of new counterterrorism bodies like the Global Counterterrorism Forum and the FATF, the Financial Action Task Force, that's been repurposed. All of these are producing massive amounts of normative content. And my experience as special rapporteur is that I find myself in country positions where states are telling me that they're in compliance with recommendation 8 or 25 or whatever it may be of the FATF. And I remind them that they have a treaty obligation, and they will effectively tell me that their, quote, soft law normative standard is more important or has more compelling reasons of compliance or greater sanctions applied to them. A good example of that in the fair trial area is the development of what are so-called battlefield evidence principles, which are the new kind of standards being pushed by a number of these, pushing directly against the right to fair trial. So Professor, in answer to your question, there's the both updating piece, but really what's pushing back against the primacy and ascendancy of these normative standards as the primus, not only the primus inter partes, but the place where we would go to expect observation and enforcement of law, and the undermining of those standards, as well as their interpretive, authoritative interpretive outputs by counterterrorism and security bodies.
Thank you, Professor, for your kind and instructive answer. We have actually 2 questions that have been written via chat, but unfortunately they are directed at ECHR judges, and Judge Albuquerque had to leave while Judge Turkovic, as I told you, was not able to make it. So I see if someone is raising hand. Yes, Mrs. Matilde Ventrella, you may go ahead. Thank you.
I don't know what's happening. Can you hear me?
Yes, we can hear you clearly. Okay. Go ahead.
Thank you. The question is for Professor. My name is Dr. Matilde Ventrella from John Moores University. And my question is for Professor Elena Valentini, who I congratulate for her presentation on the administrative detention in Italy. The thing I'd like to ask you is about this continuous willingness of the government to conclude agreements with Libya. When Libya, this is my understanding, Libya is not a safe country. I mean, it's not part of the Refugee Convention, and there have been different reports from the UN which state that the state of human rights in Libya and the detention of immigrants is very in clear violation of human rights. So I do not understand why there is still this willingness to conclude agreements with Libya. I mean, which is not a safe country. So if you could clarify this, I would be very grateful. Thank you.
Can I speak?
Yes,
I have no answer. I completely agree with the question. Is not a question, but a consideration that respect to. I'm completely agree, of course.
That's great. Thank you, Professor. I got a sign that Mario Giulia would like to come in. She has, I think, recently written on this topic. So, Maria Giulia, if you wish, you can also make an observation, make a comment. I think you might have to raise your hand so that, okay, great, so that our technician can give you the floor. Okay, Maria Giulia, I think you can activate your microphone.
Okay. Oh, yeah, thank you, Paolo. Yeah, I think that these policies of agreements and negotiation of agreements with Libya falls within the process of externalization of migration controls. And of course, Italy is on the forefront of these policies. The idea is to avoid and escape responsibility by delegating to a third country outside Europe the process of containment of migrants. And I think Professor Valentini has expressed also very well in her presentation the risks of negotiating and collaborating with Libya in the creation of offshore detention camps and of course the outsourcing of the problem and of the migration burden outside the borders of Europe, which is of course extremely problematic because still states, European states, bear responsibility and might have jurisdiction even operating beyond borders.
Thank you very much, Maria Giulia. Well, I see that there are no further questions. So I would like to conclude by thanking once again the University of Bologna and the John Burr Universities for having supported this event. And I'd like to extend a special thank to Ms. Leslie Swift for her technical assistance through the very end of this webinar. Thank you finally to our presenters, speakers, for providing us with a very provocative set of talks today. And I would like to thank you all for coming, however, virtually. Goodbye and stay safe. Thank you.
Thank you.
Thank you very much. Bye.
Thank you.